All right, guys, welcome back to the channel. So we got huge news. You've probably already seen it, but the Supreme Court is actually picking up a case dealing with firearms and the disco cabbage or the jazz broccoli or Mary Jane or whatever you want to call it. Guns and weed, guys. Let's talk about the guns and weed. All right, so we all know living here in this particular state, Connecticut, that's what we're talking about, smoking marijuana, having a medical marijuana card is not a disqualifying factor when it comes to purchasing firearms or having your permit. But it is a disqualifying factor when it comes to buying a gun at a federal level. That's filling out your 4473. One of the questions they ask is that you're not addicted to marijuana or any other controlled substance, regardless of what your state says. I've got this article here, and this is coming right from pbs.org. I'll link it down in the description below. This happened just a couple days ago. The Supreme Court said on Monday, and just so you all know, that's yesterday in this time frame. For you, it might be a couple of days. They said on Monday they will consider whether people who regularly smoke marijuana can legally own guns in the latest firearms case to come before the court since 2022 decision expanding gun rights. Donald Trump's administration asked the justices to review a case against a Texas man charged with a felony because he allegedly had a gun in his home and acknowledged being a regular pot user. The Justice Department appeals after a lower court largely struck down a law that bars people who use any illegal drugs from having guns. We were kind of hoping this would come up with Hunter Biden when he got busted for lying on the 4473. And, you know, the question basically is, are you a current drug user? And at the time, it could be argued he was not using drugs. Thus, he was not lying. Well, we all know he is a drug addict. Now, we were hoping, even though he's getting convicted of this and he's going to go through the courts and all this other stuff, that he would be able to appeal it and it would work its way up to the Supreme Court and we'd get a final answer on this. Basically, because when you fill out your 4473, you are literally violating your own Fifth Amendment rights. You are diming yourself out. Just saying. I mean, that's the way I view it. But we never got that opportunity because the auto pen pardoned him. And if you think otherwise, you're fooling yourself. Let's go on with the article. Last year, a jury convicted Hunter Biden of violating the law, among other charges, and his father, then President Joe Biden, later pardoned him. Auto pen. Arguments probably will take place in early 2026, with a decision likely by early summer. Republican administration favors the Second Amendment rights, but government attorneys argue that the ban is justifiable restrictions. Here's my thing. In Connecticut, we have no law that governs you drinking alcohol while armed. We just have a law that says your blood alcohol can't go past 0.08. Now, my rule of thumb is that you never do anything while in possession of a firearm that will alter your mental status. Okay, I always joke that pound the caffeine, take the Motrin, and that's about it. Don't drink, don't smoke weed, don't eat magic gummy bears, don't do anything like that because you're just opening up a can of worms and you're asking daddy to punish you. So that's rule of thumb. Now, even if this is cleared up and they say, hey, you could be a regular weed smoker and still have your guns, I would still suggest you be smart and not smoke weed while armed because, well, you're making piss poor decisions at that point. You do one or the other. All right. You want to smoke weed? You're an adult. You're a big boy, big girl. You do that at home and pray to God nothing happens. Do not do it out and about while having your gun. Don't smoke weed and try to go to the gun range. Don't smoke weed and then try and go buy a gun. You will show up, you smell like weed, you're gone. All right? Article continues. They asked the court to reinstate the case against Ali Daniel Hamani. His lawyers got the felony charge tossed out after the Fifth Circuit Court of Appeals found that the blanket ban is unconstitutional under the Supreme Court's expanded view of gun rights. The appellate judges found it could still be used against people accused of being high and armed at the same time, though. So you can't just be like, hey, I smoke weed, not right now, that's why I haven't got my gun. And, well, it's illegal, technically. And that's how they were getting people. Gun in the home, regularly smoking weed. But if you're high and have the gun simultaneously, yeah, that definitely, to me, is a no-brainer at that point. But just you partake in smoking weed and you own guns and you're not doing those things simultaneously, shouldn't be a problem. The Justice Department argues the law is valid when used against regular drug users because they pose a serious public safety risk. The government said that the FBI found the gun and cocaine in the search of his home as they probed travel and communications allegedly linked to Iran. The gun charge was the only one filed, however, and his lawyers said the other allegations were irrelevant and were mentioned only to make him look more dangerous. The case marks another flashpoint in the application of the Supreme Court new test for firearm restriction. The conservative majority found in 2022 that the Second Amendment generally gives people the right to carry guns in public for self-defense, and any firearm restrictions must have a strong grounding in nation's history. This would be Bruen. History, text, and tradition. If you don't have it, you can't make the law. Now, we all know here, Connecticut, California, Washington, Illinois, Jersey, Mass, all these states, they don't care about that. And we've seen recently the Second Circuit Court misinterpret, ignore, or abuse Bruen to get what they want or what they deem necessary. And these cases have been slowly moving up to the Supreme Court. The landmark 2022 ruling led to a cascade of challenges to firearm laws around the country. Through the justices have since upheld different federal law intended to protect victims of domestic violence by barring guns from people under restraining orders. Now, when it comes to crimes of violence, restraining orders, or if someone has a history of violence, there are ways in the Constitution to strip rights away from people. That's not what we're talking about. What we're talking about is you want to partake in some recreational marijuana, which these days nobody really cares about. I don't understand why it's still a Schedule I drug at the federal level. It mind-boggling. It's up there with heroin and cocaine. Literally, it's a plant that grows in the wild. It's like tobacco. And I've seen studies where they consider tobacco and just regular coffee, because of caffeine, more addicting than heroin itself, mainly tobacco. So let me know down in the comment what you guys think. Should the Supreme Court find in favor to where you can smoke weed and have guns, just not at the same time? Would you support this? Do you think this is a slippery road to go down where drug users might go around and do bad things because they also now have the ability to have guns? You guys let me know down in the comments section if you agree with this or if you disagree with it. Should be interesting. All right, that's all I have for you guys in this video. I will see you all in the next one.